Okay, welcome to chapter 33. We're going to be talking about agency liability and termination. So we're really continuing our exploration of employer-employee law, to tell you the truth here. All right, let's move on and talk about the scope of the agent's authority. So where does the agent get the right to do certain things? Well, the principal's liability arises from whatever authority he gives to the agent. So in the previous chapter, I was talking about how I had a friend of mine go to a junkyard to get a differential for my daughter's van. And generally, his authority would be whatever I told him to go get, and my liability would be the same thing. So if I say, let's suppose I did an expressway, and the easiest way to see an express liability would be I write out something for the owner of the junkyard, and I say, or salvage yard, and I say, this is my agent Mike, and I am sending Mike to purchase a differential for this van, and here's my Visa and MasterCard number, whatever, and here's the amount that he can spend for the differential. So that would be a express grant of authority. And now sometimes it's just implied. If I called up and said, "This is my buddy Mike's going to come, and he's going to be looking for a differential," well, it's implied there that I'm going to pay for it. So you can have authority derived either expressly, and that's the easiest way to see, or implicitly. Now, express agency then is defined as the exact or written authority. So I might say, here you go, here's what Mike can do. But let me give one that's perhaps a little bit closer to where we are. The classic example here is the written power of attorney. So when someone comes to me for a will, one of the things I frequently do is I prepare a power of attorney. And this says, okay, you have the authority to do certain things under this power of attorney, to conduct certain things. So it can be a very general power of attorney, which really gives huge amounts of power, or it can be very specific. It can be durable. So one of the things, if someone becomes incapacitated, generally a power of attorney lapses, believe it or not. So for most cases, we really prefer durable powers of attorney, and those are going to survive any incapacity. Now, it's got a reference there to the 13th edition. The actual one for our edition, which, believe it or not, we're using the 15th edition by this point, is page 621. So you can see a copy of the general power of attorney right there. Okay, the EDR, the Equal Dignities Rule. This is important because what the EDR says is that if you're going to give authority to someone, you're going to have to meet the same standards as if you were the one doing what the agency is doing. So if you remember, under the statute of frauds, which we covered back when we looked at contracts, we said that certain contracts must be in writing. Well, if the contract must be in writing, then the general rule is going to be the agency must be in writing. So if I'm going to hire an agent to buy or sell land, to answer for debts of another, to have a contract that can be completed in 1 year, or contracts over certain amounts of money, things like that, then that's going to have to be in writing. If you don't, then the contract becomes voidable. Now, there can be exceptions to this if you're a CEO who's acting in the normal course of business without written authority. That's going to be one of the big exceptions. And it doesn't apply if the principal is actually present while the agent's acting, or if what the agent is doing is merely perfunctory. All right, implied and apparent authority. So Implied authority arises because of the agent's position inside the company. Now, again, I keep using the term agent, and I've used servant, but we could use employee here if you think about it. We can assume that people have liability because of where they are. If you've got a purchasing agent, it would assume that he has the authority to purchase. And it could be because of what's customary in a business. We also have apparent authority, which is pretty much implied, but where the principal acts like the agent has the authority to act, directly or indirectly to a third party. At that point, we say, yeah, this pattern that is going to be created is really going to prevent someone from denying that the pattern exists. Okay, sorry about a brief interruption, but picking up with parent authority and estoppel, parent authority would be where the principal acts like the agent has the authority to act, either directly acts that way or indirectly acts that way. Often this arises as part of a series of repeating acts, and then the principal might be stopped or prevented from denying it. So this can arise where the agent has possession or parent ownership of the principal's property. So let's suppose the agent is selling something. The principal has entrusted him with it, and if he was dealing with a third party, even if the principal didn't say directly sell this thing, since you've already entrusted an agent to do this routinely, you could be prevented from denying that the sale was legitimate. Okay, there are certain emergency agency powers. So there could be an unforeseen emergency that could expand an agent or an employee, if you want to look at its duty to do this. So again, not a terribly common event. So it could be something like, I guess your book talked about how someone was drilling and there was an emergency, and then the agent who was the driller in a Pacific, I think it was an engineer for a Pacific drilling company, as I recall. So he would be acting within the scope of his authority if there was an emergency, a medical emergency, and this agent who was the drilling agent gave authority to cover the medical bills of somebody. So the agent basically has to be unable to communicate with the principal to receive the actual authority to do it in order for emergency agency authority. Then we've got ratification. This is where the principal affirms the acts of the agent. If there is no ratification, then this is treated as an unaccepted offer. But to have ratification, the agent has to be acting for an identified principal who later decides to accept the action or affirm it. The principal must accept all of what the agent did. He can't pick and choose and say, well, I'll just take this part of the deal, but not that. The affirmation or ratification must occur before the third party tries to withdraw from the agency. Obviously, the principal themselves has to have legal capacity. Of course, you have to have that form the agency anyway. And all material facts of what the agent was getting the principal into have to be known. If there's some unknown or hidden part, then later the principal should be able to rescind his ratification. Again, these are fairly rare events. Okay, so liability for contracts signed by the agents. Let's talk about the agent's liability. So as an attorney, you are often going to be acting for other people. So often what I will do is, let's suppose I'm settling in negotiation for somebody and it's a slip and fall claim. So I'm negotiating with the insurance company. Well, I can sometimes sign the contract if I have agency authority and accept whatever the insurance company is offering my client for the slip and fall. So an agent's liability is often based upon, of course, what type of principal we have. And there's three broad types here. We've got the disclosed agent, we've got the partially disclosed agent, and we've got the undisclosed agent principal. So in the disclosed agency, I basically say, hi, I am James Chapman, attorney at law. I'm representing John Smith. So this is a disclosed agency. And you can see how everybody there knows that I'm the agent and everybody knows who the principal is. Then there is a partially disclosed agency or agent where I introduce myself. Hi, I'm James Chapman. I'm representing a client. I don't tell you what his name is. The third is when I show up and I say, hi, I'm James Chapman. I'm here to negotiate with you. Didn't say that I'm representing a third party. So you've got disclosed, partially disclosed, and undisclosed. Now, if I am acting within the bounds of my authority for either a disclosed or a partially disclosed principal, then the principal has liability. So again, I'm James Chapman, I'm representing John Smith, or I'm James Chapman, I'm representing a third party, and you deal with me and I sign the contract, then basically the principal has liability there. If there is a disclosed principal, I'm James Chapman, I'm an attorney representing John Smith, then I have no liability as the attorney there, as the agent. If it's partially, then I may have some liability. I can be sometimes bound to the contract as a partially disclosed agency, particularly if I exceed the scope of my agency. But if it is an undisclosed agency, the principal can still be bound, but the agent himself often has liability here. So there can be some major exceptions to these rules if the undisclosed principal was expressly excluded in the contract, if the contract was a negotiable instrument, if the contract was a personal duty, like you hired me not knowing that I was working for another artist, that would be void. If the third party wouldn't have entered into the contract if he knew the principal was involved, then the third party can often break the contract itself. So I'm going to give you an example here of how this could arise, because this can get a little confusing for parties. Back in the, I guess it was the 1950s and in the 1960s, Disney Corporation, Walt Disney at the time pretty much ran it, obviously, it's his name, his company, set up Disneyland in California. And all of a sudden, when it became a success, the land around Disneyland became very valuable. So he had difficulty expanding the park any further. So when he went to set up Disney World, what he did is he wasn't going to go into Orlando and say, okay, I want to buy 1,000 acres. Because as soon as he would have done that, all the acreage around him would have become valuable. So instead, what Disney did was he formed subsidiary corporations. And those corporations purportedly were just going to run orange groves and things. And they would come in and they would buy land, large tracts of land where Disney World is today. And they would say, look, we are Acme Fruit Company. We want to buy your land. And the farmers would say, okay, what are you going to pay? And they'd pay something generous but not outrageous. And in this way, over a period of years, Disney, by acting as an undisclosed principal, was really able to vastly expand the amount of land he owned so that when he went to build Disney World, he didn't have to pay outrageous sums of money for adjacent property. Okay, what happens when an agent commits torts? Well, obviously the agent, first and foremost, is liable for his own torts. But sometimes the agent or the principal may also be liable for their torts. For example, if they were also committing the tort, if the principal authorized the tort, said, all right, go ahead and do this, go ahead and commit this civil wrong. If the agent is unauthorized to do it, but it's made within the scope of what he was hired to do. Also, if, strictly speaking, the agent is an employee, because this is kind of an extreme form of agency. Now we're getting close to employer-employee. If the agent is deemed to be an employee, then generally the employer is liable. And this is a doctrine called respondeat superior. Because as the modern business world developed, we had agencies and we were saying, well, you know, can a worker be an agent and all this? And eventually we said, you know, no, this is really almost an extreme form of agency where an employee is. And if you're a true employee, then you're going to be able to bind the guy that hired you. Now, technically he's your principal, but he's your employer. All right. Principals can be liable if an agent represents material facts to a third party. And this is very critical that there is apparent or actual authority to make representations so that it was in the scope. Now, if it's fraud, the principal can be liable if the agent acted for the principal's benefit or his own benefit. But we really look to see why he's in that position. Now, if it's an innocent misrepresentation, because fraud really requires that you know that you're lying and you intend to deceive, well, innocent misrepresentation really calls for rescission, not any sort of penalty against the principal. Principal's liability for the agent's negligence. This falls under respondeat superior, and here's where you're going to see somewhere master-servant. This is typically a very strict form of liability. So if you're running a grocery store and one of your employees spills a gallon of milk and doesn't clean it up and I slip and fall, yes, the agent or the employee, what you would have called in the old days the servant, it has individual liability, but so does the master. And it's really strict liability. If an employee hurts a third party while he's in his job, then the employer has vicarious liability. And we don't need to show that the employer made any mistakes, the employee made the mistake. And this works well economically because employers are better able to bear these burdens of liability than simple employees. Now, it only applies, though, if the employee is acting in the scope of his employment. So let's go back to our grocery store example. You're working on the clock, you're stocking the milk shelf, counter, whatever it would be, and you drop a gallon of milk, spill, someone slips and falls. Great, we got liability there. Employee, employer, master servant, agent principal, however you want to frame it. We got liability, respondeat superior, slip and fall guy can sue. But let's suppose that after the job, the employee comes back into work and is doing his personal shopping and he spills a gallon of milk. Well, at that point, okay, he's really not an employee. He is outside the scope of his employment and doesn't really bind the principal. So what factors do we look at? Well, did the employer tell the employee to do it? That's going to be big. Was it something commonly done? When was it done? How was it done? Where was it done? Was the employer's interest advanced? Was it of private benefit to the employee? That's going to make it less likely the employer is liable. Did the employer give the employee the ability to do it? That's going to make it more liable. Did the employer have cause to know they would do it? That's going to make it more liable. Is it a crime? Now, interestingly enough, the more serious the crime, the less likely the employer is typically liable, because usually you're not liable for the crimes of your employees. We start to use some pretty cool language here. We use the term detour and frolic. So let's take the example, say, of a UPS driver. We're getting near the Christmas season. And the UPS driver is delivering packages, and he pulls up my driveway and he runs over my cat. Now, I don't have a cat because I'm sane, but would UPS be liable? And the answer would be, well, if he wasn't paying attention and ran over my cat, he should have been paying attention. Clearly, the employee is liable. Was it part of his job? Yes, it was. Okay, then we're going to say that UPS is liable because there's liabilities within the scope of employment. But let's suppose we have a rule in UPS that when you take lunch, you don't drive your truck back to the warehouse. You can park your truck someplace, go in and eat, come out. So he the UPS driver parks his car in the street and runs over a cat. He's not delivering packages. He is on what is a detour. It's really part of his job a little bit, but he's not directly serving it. Therefore, UPS has liability. Let's change it to a frolic, which is a gross departure. The UPS driver decides, hey, I need to help my brother-in-law move furniture out in Asheville, North Carolina. So I work in Raleigh. I'm just going to take the UPS van. I'm going to drive out there. Well, I drive out to Asheville with the UPS van without the authority of the company to do it or permission. I run over someone's cat. That's a frolic. UPS is not liable there. Borrowed servants. If an employee has been directed by an employer to work for somebody else, then the question is, who has primary right of control? Whoever has primary right of control when the injury occurs of the employee, they're the ones that are liable. Notice of dangerous conditions. We are always going to assume that employers have knowledge of any dangerous condition if it's been discovered by an employee. And there's really no way around this. You can't say, well, he didn't file a proper report. You've got liability. Intentional torts. Most intentional torts are unrelated. So let's suppose my UPS driver gets mad and punches someone in the nose. Well, that's really unrelated to his job. Therefore, the employer wouldn't have liability unless it's in the scope of employment, or if the boss at UPS said, well, go punch that guy in the nose. Or if I hire someone who has a reputation for hitting people. Or if previous UPS drivers have hit people and I don't say anything about it. All those can create liability, but the general rule is no. Now, usually, and this goes back to our independent contractor we talked about before, usually employers are not liable for the acts of independent contractors unless they try to exercise too much control, unless we're just calling them an independent contractor but they're actually employees, or they're engaging in some ultra-hazardous activity. Crimes. Typically, when an employee or an agent commits a crime, there is no liability unless the employer or employer are doing it together, or it's certain regulatory violations. Now, what about subagents? Because very often you'll have a general contractor to say build a house, and then he'll build, he'll hire a plumber, an electrician. So an agent can hire subagents if it's to perform a definite duty like plumbing, or if it's custom or uninspected, and the results of which is the principal can be liable for the acts of the subagent. So I hire a general contractor to build a house. He hires a plumber. The plumber screws up and hurts someone on the job. I am liable. I'm liable through my general contractor. Termination of an agency. When an agency terminates, so does authority. However, you have to tell everybody that agent is dealing with that the agency is over, or apparent authority remains. You can have termination of agency by acts of the party. Now, obviously, it can lapse. We can say what's a reasonable time for it to end, or it can end because we say this agency lasts a year. It could end because the purpose was achieved. You hire someone to build your house gets built, the agency's over. It can happen because of a specific event. It can happen because of mutual agreement. Hey, let's get rid of this agency. Sometimes an agency ends because one party wants to end it. I always tell my clients, anybody can get out of any contract if you're willing to pay the cost. So as a general rule, either party can end an agency. But power and right to end agency might be separate, because you can end it at any time, but you might have liability. Let's suppose I'm a realtor. I have a real estate agent working for me who's selling houses, and I decide I'm going to fire him. Well, I can fire him, okay, but if he's already sold a bunch of houses, okay, well then I'm going to have to pay him whatever it's going to be to close those houses. Notice of termination. The principal has a duty to inform any third party that agent routinely deals with. And sometimes it's done by, sending out mail, sometimes done by individual contacting, that the agency is over. If you don't do this, then apparent authority continues. You don't need a particular form, there's no standard, but you should do it. It's important. Now, of course, we can have termination of agency by operation of law. If the principal dies or the agent dies, therefore, the agency itself is dead. Change circumstances, some event that would effectively end it. So let's suppose we have an agency to build shelves in my house, and my house burns down. Okay, well, the agency's over. Bankruptcy usually ends agencies. Wars that would interfere with a agency, they also end agencies. Okay, at that note, we're about 25 minutes in. I will see you for, I think we're up to chapter 34 next. See you then.